We have breaking news out of federal court in Illinois where Judge Stephen McGlynn is holding a trial involving the Illinois quote-unquote assault weapon ban. But today's video is going to be about some breaking news that an online newspaper journalist has broken, that we're going to connect some dots for you in this video involving, ready for this folks? Bans on suppressors. Very important topic if you want to go after the NFA. Let's talk all about what just happened in federal court in Illinois just now. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. We must always learn from history. We must also learn from the mistakes of others. Israel Disarmed puts all these things together in a short little volume you can pick up on Amazon. And if you already own a copy, I know many of you do, feel free to leave a review on Amazon. Always enjoy hearing comments, criticisms, and attacks on my work. I learn from all of it. All right, folks, so this is important news. I don't think a lot of people have picked up on this. Excellent reporting to begin with. Excellent reporting to begin with at Bishop on Air. That's at Bishop on Air on X. He has been tracking and giving a play-by-play, blow-by-blow discussion on X. That's at Bishop on Air. I'll put a link to it in the description of this video. Of the blow-by-blow trial that's been going on this week in federal district court in Illinois. This is a big fight over whether or not the Illinois quote-unquote assault weapon ban is constitutional. Now, Judge McGlynn had previously ruled in favor of the Second Amendment and joined the law. It went up to the terrible anti-gun panel of Judge Frank Easterbrook and Judge Diane Wood in a 2-1 decision, split decision, 2-1 decision. Judge Easterbrook and Judge Wood, undeniably absolutely terrible anti-gun judges who are bitter, in my view, that neither of them made the U.S. Supreme Court. No one should take getting appointed to the Supreme Court as a privilege, as an entitlement, I should say. It is a privilege and an honor, and it is very difficult to get. And the fact that both of those judges are bitter, in my opinion, that neither of them were appointed to the U.S. Supreme Court and taking it out on the U.S. Constitution is terrible. Nevertheless, I digress. It was a 2-1 decision against the Second Amendment where they bollocksed up the Supreme Court precedent 6 ways to Sunday, that precedent dealing with how do you deal with an assault weapon ban or any kind of a gun ban, because Heller already did the answer. Heller already set forth the rules, and they ignored that and made stuff up, really just made stuff up. But they remanded it back down, having ruled against the Second Amendment. They sent it back down to Judge Stephen McGlynn in the Southern District of Illinois for a trial on the issues that were flagged by Judge Easterbrook and Judge Wood. None of this is really necessary under the law or the Constitution. Nevertheless, it was ordered by the Seventh Circuit Court of Appeals, sent back down to Judge McGlynn, and he has been holding a bench trial, which means there's no jury involved. The decider of fact and the conclusions of law will be Judge McGlynn himself. Now, with that stage set, at Bishop on Air has been reporting these details, what's been going on every day with the various witnesses and conversations involving the judge and the witnesses and the lawyers and the witnesses and the like. Major news here. I'm not sure everyone fully appreciates what a good sign this is, but I'm going to connect the dots for you right here and right now. You see, Judge Stephen McGlynn has multiple Second Amendment cases on his docket right now. The one we always talk about is this huge one dealing with the Illinois quote-unquote assault weapon ban, dealing with magazines and the different kinds of semi-automatic rifles. We've talked all about that. There's a lot of lawyers involved, a lot going on there. But there's another case, and that's what I want to talk about. There's another case in front of Judge McGlynn right here and right now. That is not the subject of this trial. The name of this case is Carlin Anderson and Dave Clark. That's Carlin Anderson and Dave Clark against Kwame Rao. Okay, I think there may even be a related case to this. I don't want to, but it doesn't matter. The bottom line is there are a case or more case. There are multiple cases, at least one case, and maybe even more than one case, dealing with the Illinois ban on suppressors or silencers, if you will, because we know that under federal law, the National Firearms Act regulates suppressors, meaning you're not allowed to own a suppressor without getting that registered under the National Firearms Act and paying the SNAP tax and blah, blah, blah. You know how that works under federal law. But Illinois and some other states went further, and they actually have banned the possession of suppressors. And that is what Illinois did. That law has now been challenged on Second Amendment grounds in federal court, in the United States District Court for the Southern District of Illinois, and the judge that was assigned that case was none other than Judge Stephen McGlynn. Okay? So Judge McGlynn has a suppressor case pending in front of him. I think there's a motion to dismiss pending. I don't think it's been ruled on yet. That's pending. And he's got this separate, kind of legally unrelated trial involving the assault weapon bans. Now, how am I going to connect the dots with you and make you very happy for the day? The answer is, according to the reporting of @BishopOnAir, who's been covering the trial on X for all of us. I encourage you to follow him on X, @BishopOnAir. This is what he tweeted out or posted on X. Quote, Judge McGlynn talks about suppressors and need for others in the House to hear. Watt, who I believe is the expert witness, by the way, says very important. McGlynn discusses common use test in SCOTUS precedent. Watt says he was not asked about that. Judge McGlynn said reason for Second Amendment, old people to defend themselves, people who are mobile, disabled, strong, weak. The judge then says, wife is 100 pounds, shotgun recoil, too strong. What should she have? Watt recommends a carbine. Judge McGlynn says, quote, when seconds matter and police are minutes away, people are on their own, question mark, close quote. And Watt says, as a retired police, he recognizes that. Okay, so that's the tweet. I also posted it here. You can check it out from Bishop Online. Now, what's interesting is this, is the first part of that tweet or that post talks about suppressors and the need to hear. This is very important because this means that the assault weapon trial that's taking place, we understand that assault weapon is a political propaganda term perpetrated by the left. They're very good at labeling things, okay? Judge McGlynn obviously asked some questions about suppressors, and it sounds like he got some good information and sounds like he understands that suppressors are about protecting hearing. It sounds as if he understands based on what's going on in the courtroom. And of course, I'm not in the courtroom. I'm not there observing. I'm not looking at every word. So I'm relying on @BishopOnAir, but it looks pretty good to me. And I suspect this is true because anyone that studied firearm technology at all, and I think Judge McGlynn has demonstrated over and over and over again, he understands firearm technology better than 99% of the federal judges in America. So Judge McGlynn talking about suppressors and the importance of protecting your hearing is very important. Because we know that unlike a gun, which can obviously be used to hurt somebody for good or ill, suppressors are pure safety devices, right? These protect your hearing. They protect the hearing of others around you. If you have to touch off a round, at night to fend off and stop an attacker, and your family's in the home, you want to protect your hearing, and you want to protect the hearing of your family members. So suppressors are, of course, something that protects the hearing when you use a firearm. So it facilitates the use of a firearm. It improves the use of a firearm. It makes it safer, like a safety. Okay? Now, this is a very big deal. Why? Because the argument being advanced in the Anderson versus Rao case on suppressors is that suppressors are an arm, as in the right of the people to keep and bear arms shall not be infringed. We know from the Supreme Court precedent of Heller that arms includes anything that can be used offensively or defensively. And we know from the Bruin language from 2022, the Supreme Court said that anything that facilitates, bing, 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 do you hear what I just said? Anything that facilitates armed self-defense is an arm. Suppressors obviously facilitate, improve, help with self-defense. The scenario I just discussed, which is the scenario that Judge McGlynn just talked about in open court during a trial on the quote-unquote assault weapon ban from Illinois, which means that Judge McGlynn gets it based on this reporting by @BishopOnAir. So this is very good news because this, to me, as I read this, connecting dots, I'm pretty good at connecting dots, This means that Judge McGlynn has connected the dots about suppressors and its relationship to the Second Amendment and its relationship to how suppressors improve the use of firearms and thus constitutes an arm as a matter of text under the Second Amendment. And as you know what I'm about to say, once an arm, i.e. the text of the Second Amendment, is satisfied, and that a modern-day gun control law is implicated by the text of the Second Amendment, that modern-day gun control law, such as a suppressor ban in Illinois, is presumptively unconstitutional. It's presumptively illegal. Presumptively. And the only way the state of Illinois can come back and overcome that is by saying that there's a long-standing tradition of firearms regulation dealing with banning suppressors. That's not going to happen. You know why I'm going to say what I'm going to say, which is that under the Heller precedent, which is the law of the land, I know the anti-gunners like to pretend Heller doesn't exist, but Heller is the law of the land, and Bruin did not override Heller. Bruin simply supplemented Heller. Heller says that the only way you can ban any arm in American life is if it's dangerous and unusual, and relatedly, a corollary of that, and this is the key, if an arm is in common use by Americans for lawful purposes, it cannot be banned because it is not, by definition, dangerous and unusual because it's not unusual. So here, when it comes with suppressors, not only are suppressors not dangerous, for the reasons we've talked about, it's a safety device. They're not unusual because by last time I checked, there's somewhere north of 3 million suppressors, according to the NFA registry, as I recall. It's some number of millions of suppressors in the United States that have been registered with the NFA and the ATF under the NFA. That is a very large number and certainly in common use, and thus, by definition, not dangerous and not unusual. And again, suppressors are not dangerous. They are safety devices. And no more than a fire extinguisher is not dangerous. It's a safety device. So suppressors are neither dangerous nor are they unusual. And based upon this post by @BishopOnAir, where Judge McGlynn is talking with the same witness in the colloquy there, he's connecting the dots between suppressors, he's talking about the Supreme Court precedent, and he's talking about the in common use test. Why is a judge connecting those dots with a single witness? Well, anything's possible. We can all speculate as to what he's doing. Maybe I'm totally wrong. But if it were me and I were a betting man, which I actually think I am, but set that issue aside, guess what? I'm betting that Judge McGlynn has connected the dots and realizes that indeed suppressors facilitate armed self-defense, therefore they're arms, therefore the text is satisfied, therefore the in common use test applies, therefore the government bears the burden to show that something's not in common use, because never, ever, ever forget the following. Write what I'm about to say down if you don't know it already. When you talk about the in common use test, the burden of showing that something is not in common use is on the government. Hear what I just said? The Second Amendment plaintiffs do not have to show that anything is in common use. Why? Because the in common use test derives itself from the traditional history or historical tradition of firearms regulation, which means it's at the historical level of the Bruin-Heller test of text first, burden shifts to the government, history done. So the bottom line is, because the in common use test derives from the history of traditions involving firearms regulation in the United States, the burden of proof is on the government to satisfy that prong. Thus, the government bears the burden to show that something is not in common use. Not in common use, because the government bears the burden at the historical level of the text first, burden shifting, historical level analysis second. All right, never forget that. The last thing I want to mention about this, just as a reminder, to the extent somebody wants to talk to you at the gun club or at the American Legion Club or at the Elks or whatever it is that you guys all belong to, or at the bar or at the office, somebody wants to say, well, suppressors are not guns. Well, as you know, the word arms in the Second Amendment covers more than just firearms. We know that from the Catano case, which covers stun guns. Moreover, keep in mind that if you don't believe me that a suppressor is an arm, as in the right of the people to keep in their arms, then who can we trust? Who are the ultimate anti-gunners in many respects? That's Congress. Congress. And guess what Congress did in the National Firearms Act? I'll show you. You see, folks, if you look at the National Firearms Act, Section 5861D as in dog of the National Firearms Act, it says that it's unlawful for any person to receive or possess a firearm, listen carefully, a firearm that is not registered to him in the National Firearms Registration and Transfer Record. including a silencer. Hear what I just said? Congress treats a silencer and a suppressor as a firearm under federal statutory law. So if anyone says, well, a suppressor is not a gun, it's not a firearm, then the question is, well, why did Congress define it as a firearm in the National Firearms Act and has been treated as such since the 1930s? So if you can't trust Congress on this, who can you trust? That's obviously a bit of a joke, but the point is that even Congress, and if you look at these state laws dealing with suppressors, they all treat it as a weapon. And what is a weapon? A weapon is obviously something that can be used offensively or defensively. So again, to the extent someone wants to say that a suppressor or a silencer is not implicated by the text of the right of the people to keep and bear arms because a suppressor or a silencer is not an arm, just tell them that Congress has disagreed with that definition and that argument since the 1930s, as do all these states that define suppressors as firearms, or weapons at least. And obviously these are things that can be used offensively or defensively. The Supreme Court says that anything that can be used offensively or defensively is an arm under the Second Amendment, and therefore suppressors are clearly arms textually. Thus, a ban on them is not allowed unless there's a historical tradition, and there isn't, because the only historical tradition of banning guns in the United States is something that is dangerous and unusual, and suppressors are neither. And it sounds to me, based on what's going on at the trial out there in Illinois and the great reporting of Bishop on Air at Bishop on Air on X, sounds like Judge McGlynn gets it, and I'm happy to report that. So let's just see what happens in that other case dealing with suppressors, as well as, of course, what happens in this assault weapon trial, which, of course, we'll report on as news filters in. All right, folks, hope you learned a little bit something here today. Hope you enjoyed the connection of some dots. Make sure you follow me on X at 4Boxes Diner. We have almost 18,000 followers over there. Get more information out there on a daily basis than I can get out on video. And we will see you again very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.